I'm a practitioner. I work as an attorney 4 days a week, and 1 day a week I work at the University of Amsterdam as a senior lecturer. And I've been fortunate enough to have been able to argue many copyright cases before the ECJ. As you know, not that many cases are referred in general. So in the Netherlands, about 40 cases on the whole in all different areas of law are referred to the ECJ. And we've been so fortunate to be able to work on 5 different copyright cases, including cases about the liability of online intermediaries. And the topic we can go to the next slide. The topic I'll be discussing very much relates to the exclusive rights under the InfoSoc, the 2001 Copyright Directive. Now, I understand that Julie Samnada also had a presentation yesterday about the right to communication to the public. Julie Samnada has been representing the European Commission for many, many years before the courts, including in the instances I've had the pleasure of arguing before the court, and I'm sure that was a very interesting presentation. I'm very sorry about missing that representation due to other engagements. But the communication to the public right, I'm sure Julie explained, is an issue that is being argued over and over again, and somehow the European Court seems to increase or overcomplicate the knot that it has created so far, and the untangling of the right of communication to the public becomes more and more difficult every time the European Court comes up with a new case. Now, the Tom Cabinet case about the exhaustion of rights refers or relates to a specific part of the right of communication to the public, the so-called making available right. And the court hasn't had so many occasions to actually render a ruling about the making available right. So it was very interesting to see how the court approaches that right. It's also interesting to see that, at least here in the Netherlands, the national courts were struggling with that right. So it's an opportunity, this presentation is an opportunity to go into the contents of the making available right itself. The case also relates to the reproduction right, and the big question was in this case whether the act committed by the defendants Tom Cabinet constituted a distribution or a communication to the public, and then more specifically a making available. That was the big issue. Why is that such a big issue? We can go to the next slide. It's such a big issue because if the court would determine that the second-hand sale of digital content would be an act of distribution, the consequence thereof would be that the rule of exhaustion would apply, meaning that the further sale cannot be prohibited by the rights owner. Of course, we know the exhaustion rule in physical matter, especially in relation to books. This was a case about second-hand ebooks, so digital books, but we know the exhaustion rule in relation to books. We all know that if we buy a physical copy of a book, we are free to resell that book again without the copyright owner, the right owner, being able to prohibit that sale of the book, as long as it was sold on the market in the European Union legally for the first time. So that's, in short, the rule of exhaustion applying to physical content. And the big question was, does the rule of exhaustion also apply to digital content? Next slide. Now, this particularly was an issue, as was also said by Ms. Hartman in the introduction, because of the used soft ruling, the 2012 ruling of the European Court. And this case concerned computer programs. And pretty much unexpectedly, the court ruled in this case that the exhaustion doctrine actually applies to the resale of software, and therefore the right owner, in this case Oracle, was not able to object to the reselling of its software program online. I remember when we were arguing this case before the court, and after the arguments, I briefly discussed the case with Ms. Samnada, and I said, well, the hearing actually went quite well. All the intervening member states, or practically all the intervening member states, argued in favor of my client's position, my clients being the publishers here in the Netherlands, and also some individual authors, but mainly the Publishers Association, called NUV as an abbreviation. So I was quite happy, but then Ms. Samnada said, well, actually, it was exactly the same during the arguments in the Usoft case. Everybody was arguing against the exhaustion rule before the court, including the European Commission, but nevertheless, the European Court ruled that the exhaustion rule applied. Now let's briefly go into the details of that 2012 case. In this case, it was important, if you read the paragraphs of the judgment, that Oracle was both distributing its software through physical matter, through CD-ROMs or DVDs, and through the internet. And there is one paragraph in which the ECJ says, well, in the circumstances of this case, what is actually happening is that the act of communication to the public is changed into an act of distribution. Like Houdini can change. It was a kind of a magical trick that the ECJ referred to. And because it changed, it altered the act, altered into a distribution act, the court said, therefore, the first sale doctrine can actually be applied in this case, and then there can be exhaustion of the distribution right. Next slide. Of course, as Ms. Hartman said in the introduction, this was a case about software, and therefore the Computer Programs Directive applies to the case. And despite the fact that the Computer Program Directive has been altered in 2009, it was actually a directive, the earlier version preceded the 2001 Copyright Directive. So that's something to keep in mind here. And the intention of the European legislature in the Computer Programs Directive was to assimilate the tangible and intangible copies of computer programs. Also, the court noted, and I think this is an important argument that the court used, is that from an economical point of view, there was no difference. So there was no difference whether you were selling the computer program online or whether you were selling the computer program physically through a CD-ROM or a DVD. It was exactly the same. And you can imagine that somewhere in the court's mind, there was an argument, a fairness argument, that it couldn't be possible that depending on the mode of distribution of the same product, the consequences would be entirely different, resulting in the one incident that the right holder was able to continue to prohibit the reselling of the computer program, but in the other incident, it wasn't able to do so. There was an important criterion the ECJ set in the Usoft case, namely that the seller of the first-hand computer program, making it a second-hand computer program, had to enable the use of his own copy, of his own digital copy, which is of course a practical issue because it's very difficult to check whether the seller actually does that. But that was an important criterion, and actually Usoft did ensure that that copy was being made unusable in the use of its system. Next slide. Now the question here, of course, is there a second-hand ebook market? And the importance of this case not only relates to ebooks, but of course you can imagine that if there is such a thing as a second-hand ebook, there is also such a thing as second-hand music and also second-hand films. So the case is important for the entire digital market of copyrighted materials. Next slide. Now, we had to go through quite a lot of legal instances in the Netherlands before we reached the ECJ. We were fortunate enough that it was the District Court of The Hague in a proceeding on the merits that already in that instance decided to ask preliminary questions to the ECJ. But the case was brought first in a summary proceeding, actually immediately after Tom Kabinet started its service. The publishers initiated summary proceedings here in the Court of Amsterdam before a single judge. And then eventually from that moment onwards in 2014, it took almost or more than 5 years before we actually reached the judgment. And mind you that during this entire period, Tom Kabinet continued its business. It changed its business model on several occasions, and it was able to function freely, selling second-hand ebooks. Next slide. So this is me and my colleagues Sam and Caroline and my client Martijn Davids of the publisher organization before the court during the oral hearing in 2019. Next slide. And these clippings refer to the functioning of Tom Kabinet. Tom Kabinet is actually Danish. It means empty book case. And the idea, of course, of the system was that you could quickly fill your bookcase with your second-hand digital books. And of course, there is a very quite a charming argument to make, because once we have read our ebooks, people usually don't reread them, making them different, for instance, in relation to music or possibly also to films. And they more or less remain on your e-reader, if that is the device that you use for reading your ebooks, or possibly your iPad or tablets. But they remain on your tablet unread, of course, under the terms of the license, for instance, the Kindle license of Apple, but also of other licensors. You can share your ebook within a small circle of people, for instance, your family, but that is more or less it, and that's where your ebook rests. And you can imagine that to some who have invested heavily in ebooks, that can be frustrated. So here comes Tom Kabinet and making an offer that you will be able to sell your ebook on the platform and receive the income from that, including a number of credits that Tom Kabinet grants to you in order for you to buy new ebooks. So you could create an entire circle of ebook circulation. The interesting thing for me as a lawyer, and possibly for you also, is that this startup, Tom Kabinet, the business, was primarily based on a legal ruling. So they specifically referred to the Usoft judgment. Tom Kabinet, in its first press statement, said, "We are allowed to do this by virtue of a ruling of the ECJ, the Usoft ruling." And I haven't seen any startup here in the Netherlands being established on account of a ruling of the ECJ only. So that was interesting to see. Tom Kabinet wasn't able to actually check whether the seller erases its own copy from its device. In fact, in the Netherlands, most ebooks remain on a digital bookshelf with the company selling you the ebook. So we of course have Amazon here in the Netherlands, but our biggest e-tailer is called bol.com, after bertelsmannonline.com. It's now part of Ahold, the big retail chain. But if you buy an ebook from bol.com, it remains on your digital shell even after you have downloaded it on your device. So it was difficult for Tom Kabinet to actually assure that the copy was erased. Next slide, please. Now the actual selling goes through a download link. You had to upload your download link to the platform, and then through that link that referred you to the position of the ebook on Tom Kabinet's servers. So Tom Kabinet reproduced or downloaded the ebook on its server, and then it offered the ebook for sale. And I've put an R after a number of acts that are mentioned here, and that relates to a reproduction, because there are of course reproductions being made. Next slide. Here again, Tom Kabinet keeps a copy of the book on its servers for future use, so it doesn't make copies each and every time somebody decides to resell a copy of his John Grisham ebook. It simply keeps the issue it had and then offers it again to a new seller. Next slide. Now, the Court of First Instance in the summary proceedings here in Amsterdam said that it couldn't be excluded that the use of judgment actually had a wider scope and did apply to ebooks. So the publishers lost its case against Tom Kabinet in first instance, and they appealed to the Court of Appeals of Amsterdam. Next slide. And also the Court of Appeals was finding this a very difficult issue. We showed to the court that actually on Tom Kabinet many pirated ebooks were being sold. As we all know, it's very easy to buy infringing ebooks. A few euros will grant you access to thousands of ebooks, and we were able to show through technical means that Tom Kabinet was actually facilitating the reselling of infringing ebooks. And the Court of Appeals decided to leave the copyright question aside because it was finding it too difficult, but nevertheless ruled that Tom Kabinet was committing a tort under Dutch law by facilitating the selling of illegal ebooks. So this was in part a victory, but it was also kind of a Pyrrhic victory because we wanted to prevail on the basis of copyright infringement. Next slide. We decided to go to the District Court of The Hague, which is our specialized court here in the Netherlands. It has an IP chamber. It deals with all the trademark and patent cases by exclusion in The Hague, and therefore it has judges that are very, or should be considered to be very well experienced in the field of intellectual property rights. It took a long time before the district court. They have a big backlog of cases, so the judgment was postponed several times. But ultimately, the court decided to ask preliminary questions. However, as you know, in its judgments, the court can lay down the facts of the case and also proceed the way it would deem the ECJ to rule on the matter. And in this case, the district court actually stated that there was no violation of the right of communication to the public. So Article 3 of the InfoSoc Directive was not violated. And it said so that the right was not applicable because the mere offering for sale was not a communication. The court ruled that, well, Tom Kabinet is in fact offering ebooks for sale, but in order to get access to the ebooks, you need to pay for it, and therefore it is not offering the ebooks as it's not communicating the ebooks as such, because you need to pay to get access. Second, the court argued that the supply through a download is not a communication to a public, because only a single person gets access to the ebook. And therefore, the court decided not to ask any questions about the right communication to the public. Now, of course, this was not the way we were hoping the case would go. We had lost in summary proceedings twice. Then we came before the court on the merits in The Hague. So we pleaded to the court to please ask a question about the right of communication to the public to the ECJ. If you're going to ask preliminary questions, why not also include that in your questions? Moreover, even Tom Kabinet argued before the court that that question should also be included in its list. But the court was rather stubborn in this matter and simply decided, no, I'm only going to refer questions about the distribution right, digital exhaustion, and the reproduction right. And then we came to the ECJ. Next slide. And as you know, in the proceeding before the ECJ, member states and the parties in the European Commission have the chance to submit written observations. Then those written observations are translated in all the languages of the community, and then again submitted to the parties in the case. When receiving the written observations by the European Commission, we immediately read, and we were very grateful for that, that also the European Commission was arguing that the act Tom Kabinet was performing was actually a communication to the public. Following the written observations, we received a very interesting letter from the court. The court said, we have seen the questions from the District Court of The Hague, but we would like to propose to all the parties, if they come before the court during the oral hearing, is that they also answer the question whether there is an act of communication to the public. Next slide. This, of course, was already an important hint of what was in the minds of the court and the thinking of the court. And also the court was put forward before the Grand Chamber of the ECJ, so comprising of 15 judges, the full court. And that's also an indication that the ECJ actually finds this a very important case. Next slide. Now, in its judgment, the court, as it usually does, reformulated the questions asked by the district court and indicated that it was also going to address the issue of a communication to the public. Next slide. And mainly the court said, well, the first question, the first issue we need to decide upon on whether is this a communication to the public or is this a distribution to the public? And it indicated that this question could not be answered by the wording itself in the 2001 Copyright Directive, and therefore it had to examine the context, so also the recitals of the directive, the objectives or the purposes, the aim of the directive, the origins, so the legislative history, and its consistency with international law. Next slide. And this is, of course, a way the ECJ very often deals with its cases in a very structured manner, going through all those different steps in its rulings. Now, in this case, not only did the court have to reconcile its judgment with the Usoft case, but also with the VOB public lending case. In that case about public lending, the question was whether public libraries were at liberty to lend out ebooks and whether they fell under the public lending exception in the rental and lending directive. Now, in that case, it was crystal clear that at the time of the public lending directive in 1992, they did not consider lending out ebooks simply because ebooks didn't exist in 1992. So it was crystal clear that the lending right only related to digital matter. And of course, public lending, the lending right, was an exception to the exhaustion doctrine because at first you're at liberty to resell your books, so you were also at liberty to lend out your book, your physical books, and therefore introducing an exclusive lending right was again an exception to the previous exhaustion right. And then in the directive, there was an exemption introduced for public libraries that allowed them for consideration of a fair remuneration to lend out physical books. Now, and in that case, in the VOB lending case, the court actually went as far as to say, well, under the circumstances of this case, public libraries are actually allowed to lend out ebooks under the under the rental and lending directive. And it was obviously influenced by Advocate General Spunar, who is the main Advocate General at the court, a Polish, very smart lawyer, and he added an interpretation means to the interpretation means I just mentioned in its opinion, saying that also the court should give attention to the development of technology since the time the first directive, the renting directive in 1992 was adopted. So, I mean, this argument goes quite far because it gives the court an opportunity to basically disregard the language of the directive and come up with a whole new intention and meaning of the directive itself. But this is the way the ECJ handled the issue in the VOB case. Next slide, please. Now, the ECJ looked at international law, especially the WIPO Copyright Treaty, and said that, of course, the Copyright Directive was intended to implement the WIPO Copyright Treaty, the 1996 treaty, and the concepts of communication to the public and distribution to the public must be interpreted in accordance with that treaty. Next slide. It also referred to agreed statements accompanying the WIPO Copyright Treaty, in which it was specifically said that the expressions copies and original copies relating to the right of distribution and the right of communication to the public, or distribution right, relate exclusively to fixed copies put in circulation as tangible objects, so not to digital objects. And therefore, the court said Article 6 of the WIPO Copyright Treaty cannot also cover distribution of intangible works, digital works, such as ebooks. Next slide. Then the court looked at the legislative history. It doesn't always do that in copyright cases. So it's interesting to see that in this case, it goes in depth in examining the legislative history of the 2001 InfoSoc directive, and actually stresses that it was the intention of the European Commission in its proposal to draw a clear line between electronic and tangible distribution of protected material. And remember, in the Usoft case, the court specifically stressed that it was the intention of the legislature to assimilate tangible and non-tangible matter with the Computer Programs Directive. So the clear line clearly distincts from the Computer Programs Directive. Also, it stresses that interactive on-demand transmission should be covered. Moreover, this was probably the most important new right in the copyright directive, because this was the on-demand right. This was the internet right. So of course in 2001 the main purpose was to encompass the new technological developments, meaning the internet, and it was specifically stressed over and over again that a right had to be introduced, an exclusive right had to be introduced in order for the right holder to prohibit or grant permission under his terms for the making available of its content at a time and a place chosen by the recipients of the content. Next slide. Now then, looking at the purpose, of course, the court again reiterates that the aim of the Copyright Directive is to grant a high level of protection, a broad right of communication to the public, and it refers to recitals 28 and 29, in which the directive specifically says that distribution of works only, and the distribution right of Article 4 of the directive only relates to tangible matter. And in recital 29, it is emphasized that there's no exhaustion in case of online services. Next case, next slide, sorry. Then it had to deal with the question whether an ebook is a computer program, because if an ebook was a computer program, it would fall under the scope of the computer program directive, and then again the Usoft case would come into play. This was an argument that was made by Tom Cabinet in the case, but the ECJ is very clear about the fact that ebooks are not computer programs. Next slide, please. And also economically, ebooks are different from physical books. And this is, of course, again, an argument that echoes the reasoning of the court in the Usoft case, where it said, well, the selling of CD-ROMs and DVDs is economically similar to granting access to computer programs through the internet. So here again, it's specifically distinguished from the Usoft judgment. What I find interesting in this case is that, of course, this is a factual argument. This is an argument about economics, about the market. And whenever these cases are being referred to the ECJ doesn't have an entire file before it. The ECJ only rules on the basis of the judgment it receives from the referring court and the written observations of the parties that are maximum 20 pages long. So what very often happens is that, in this instance again, the Advocate General, also Spoonar, comes up with facts it more or less finds on the internet or elsewhere or reads about in books, and these facts are being incorporated in the case itself. In this instance, it was to the help of my clients, but it's nevertheless, it's good to point out the importance that before the ECJ, and not only legal questions are being decided, but sometimes also questions about the facts. And this is, of course, a very important factual part of the ruling that you can agree or disagree with. Next slide. Now, the conclusion of the court then was that the offering of ebooks did not constitute a distribution, but constituted more possibly with, I see Peter partially disagrees with me, so hopefully they will give rise to discussion after the presentation. But the court decided, well, this isn't an act of distribution. But then, of course, the court had to decide whether it was a communication to the public. Next slide. Now, as I said before, there have been many cases about this right, but not that many cases about the making available right. So in Brein Ziggo, there's reference to the making available right, and in the PPI Ireland case. Now in the Seymour case, there's reference to the making available right, and to a certain extent in GS Media, but it hasn't been handled in depth before by the ECJ. Next slide. The court applies the criteria that I'm sure Julie Samnada also discussed with you. Is there a communication? Is there a public? And more specifically, is there a making available to the public? Can members of the public access the protected work at a place and from a time individually chosen by them? The court stressed that only the opportunity suffices. It's not necessary whether the members of the public actually get access to the work, only having the opportunity is sufficient. Next slide. Then the court argued that the act in this case actually did constitute a making available, irrespective of the fact whether people were actually accessing the work. So of course you may remember that the referring court, the district court of The Hague, said, well, they're not actually accessing the content because they need to pay before they access the content. So it's made available, yes, but it's not being accessed. And then here the court stresses, I think in accordance with its previous case law, that the mere offering of the work is sufficient for it to constitute a communication, or in this case, a making available. Next slide. Then the second criterion, is there a public? And again, you may remember me saying that the district court said, no, there is no public because there's only individual access. There's only access to a single person. But here the court stresses that also access in succession may lead to there being a public. Next slide. And this is paragraph 69 of the case, in which the court needs to reconcile its VOB case with the Tom Cabinet case. And this is, and the use of the case also. And this is a kind of a worrying paragraph, depending on where you stand in the debate. If you protect rights holders, you may find this a worrying paragraph, because the court states and emphasizes that, Peter, great to see that you agree with me. It is a very blurred paragraph, he writes in the chat. The court says, well, in this case, it's clear that Tom Cabinet doesn't employ any technical means to ensure that only one copy is being downloaded during a certain period of time, which was the fact. And that after that period was expired, the downloaded copy could no longer be used. Those were the facts in the VOB case, the case the court specifically referred to, and therefore there was a public. But of course, next slide, you can imagine that those technical means would be put into place by somebody who's reselling ebooks or music or films or what have you. So there are quite a few questions that remain in relation to the application of the ECJ of the public criterion, questions we may go into in the discussion. Next slide. Then also interesting, the court discusses the new public criterion. Now I'm sure Ms. Samnada went into the new public criterion, which is a criterion that is usually employed in secondary communication cases, retransmission cases, so to say. And in legal doctrine, there's a lot of debate whether the new public criterion should be applied in all copyright instances, because it's, on the one hand, it's a very subjective criterion. It's whether the right holder took into account the additional public when first granting permission to the use. and the question is whether it's actually or should be applicable to unauthorized communications, such as in this case, because it was an unauthorized communication. The court concludes in saying, well, there is actually a new public here, because in the license terms of the e-tailers in the Netherlands, for instance, bol.com or Amazon.nl, platforms that offer ebooks, in the license terms, the use is restricted. But because in the license terms, there is a restriction. Here you can see the license terms. There is a restriction on the reselling or the further communicating to the public. The court determined that there was actually a restriction of the amount of people or the public that the original work was being granted, the public was granted access to, and therefore it should be considered that there was a new public. Next slide. So the conclusion was that there was actually a communication to the public and making available to the public according to the court. Of course, the referring court still had to determine a number of facts, especially the facts in paragraph 69 that were stated by the ECJ. It didn't come to that because the case was settled out of court before the district court could finally decide on the matter, which was for us lawyers a shame, because it would have been very interesting to see how the court would decide on the basis of the answers of the ECJ. Next slide. There are, of course, quite a few issues that remain following the judgment. What does is there a difference between the supply through a download link or through streaming, which is of course through services such as Netflix, the main purpose? What does this mean for the licensing practice on the whole? I think on the whole, it's very important that you very carefully look at your licensing terms through the entire chain of title. There's always a long chain of title in the distribution of copyrighted digital works, also in music and also in film, and you need to ensure that, especially in relation to the new public criterion, you carefully restrict the public in your licensing terms. And of course, the final question is a one user, one copy model permitted, like in the VOP case? Now, there are a few issues that I would advise all the lawyers here present to carefully take into consideration in their practice in future instances. A few issues that they carefully need to look at, possibly also for the discussion. I see that I've taken up more than the 45 minutes of your time. So let's see if there are any comments or questions in the discussion itself. Thank you very much.